I have to tell you about a case that was brought to my attention. And I love the fact that you bring cases to my attention all the time. This was brought to my attention by somebody who's been an occasional guest on the show and a good friend of mine, Phil Myman. And he got this via email from a friend of a friend of a friend. And it is available online. And if you want the link, I'm probably going to post the blog right after the show and let you know, or Jamie can put up the link on our website. Once in a while, cases come to me that are about people in distress that I feel I must tell you about. And what I'd like to do is play the You Be the Judge game, only because this is the kind of a case that lends itself to this. So I'm going to give you the facts. The law is very convoluted on this, but I'm going to give you the facts because they're not. You have a woman who was in a relationship with a man and engaged and broke off the engagement from the man. Let's just make up a name. We'll call him Herman. I don't think that's his name, but let's just call him Herman. So her name was Donna. Donna was engaged to Herman. Donna broke up with Herman. Donna subsequently remarries a guy named Al. With Al, she has a child, but during the pregnancy with Al, in other words, while she's pregnant, Al goes to live off in Europe or something, and they're separated and they're not together. So while Donna is pregnant, she becomes friendly again with Herman, and they take up their romantic relationship again, and Herman is present at the birth of their son. What should we call the son? Stephen. We'll call him Stephen. Okay. It's important because these names go in and out. All right, so Stephen is a little boy, and Herman is present at the birth of Stephen, and the mother and Herman have a romantic relationship that lasts a few years, and then it breaks up, because the mother is not happy with whatever reason in the relationship. And 8 months after breaking up, Herman sues the court for visitation with the little boy, Stephen. He's never been married. He's not the father, but he believes that he has a right to visit and to be part of this child's life. And he goes into court, and he basically tries to allege that without him, the son will live an unstable life, that the mother is unstable, that she's not fit. And the psychiatrists never find that she's an unfit mother. Never. But what they find is that the mother cannot stand this man Herman anymore. And you could see why, by the way. Would you want a stranger intruding and going to court to try and be part of your family? And they find, the trial court finds, that it's not in the best interests of the child, Stephen, to be visited by Herman, given the antipathy of the mother. Not that Herman's a bad guy, but that given the overall circumstance, it's a very upsetting event to the family dynamic. And so the trial court says, you know what, even though this is a guy who probably otherwise has some rights under the law to visit, and I'm going to tell you about it, by the way, I didn't realize until I read this case that strangers to a family could petition to be able to have visitation. Did you know that? I didn't know that. Julia, did you know that? No way, right? You never would have thought it. And I'm an attorney and I didn't know it. But it was apparently... It was apparently established by judicial rule, not by statute, because the statute is very vague about the fact that occasionally, under some circumstances, yes, a non-relative can petition to have visitation, but only if it's in the best interest of the child. So the court comes up with this very, very complicated standard for how to determine it. And here's the bottom line. You be the judge. Okay? You be the judge at 203-845-3044, 203-845-3044. You be the judge. Should a non-blood relative, I'll make it very simple, should a non-blood relative have the right, the legal right, to require visitation with a minor if the mother objects, the mother is not unfit, and the court has already found, the trial court has already found, that is in the best interest of the child to not be disrupted? Does a stranger to the family, in this case a man who did have a prior relationship with this child, have an overriding right to visit the child if he can prove that in the totality of circumstances it's a good thing for the child? What do you think? What do you think about this? What do you think about these facts? I know, Julia's laughing. I find them to be outrageous on their face. outrageous. When I read the case, I'm not even going to tell you the answer, but I will tell you that the judge, the reason this is important is that the Supreme Court judge who wrote the opinion is Joette Katz, who has recently been appointed by Dana Malloy to be our new head of children and families. She's the new commissioner of DCF. So it is very relevant and important for us to know what she thinks, because as the commander of DCF, which is a division of state government that has come under tremendous attack for negligence and all kinds of things, it's very important to know who's at the helm and what she's thinking. And she wrote the deciding opinion of the Supreme Court on this. I'm going to give you a little bit more to this because I know I'm going, as they say, in the weeds. You know, once in a while I'm accused on this show. You're listening to the Lisa Wexler Show here at AM 1400 WSTC, 1350 WNLK, and also on Ustream, USTREAM.com, where you can watch the show. And incidentally, I am all dressed up today because right after the show, I am going to my sister's party to premiere her new Squeeze Couture line. She's coming out with a line of shapewear, which we can all use, by the way, and to compete with Spanx, and she'll be sold in all the department stores, and she's throwing this massive party at a club down in like the Tribeca area, and I'm very excited to be going, so I'm all dressed up. So if you wanted to see me today, Ustream, it's a good day. Anyway, but I'm accused occasionally of being a little bit too highbrow, intellectual, eggheady. And I can take it because I know you're smart enough to understand what I'm saying. In fact, I'm a little offended when people say that, in the sense that, what do they expect me to do? Do they expect me to continue to dumbify America? I didn't get on the air behind this microphone to continue to dumbify America. You want to be entertained dumbly, there are plenty of places to do it. You want to learn a little something new and be entertained at the same time. I hope you're tuning into this show. So what we're going to do is go to a commercial break. When we're back, I'm going to give you more facts about this case. You can look it up. It's online. But I'm not going to tell you now because that would be cheating. But here's the bottom line. Connecticut has a policy in which, under certain circumstances, a non-parent, non-blood relative, non-adoptive relative, non-anything person can petition the court to have compulsory visitation, even in cases where the parenting parent is not unfit. In other words, overcome the family presumption of family wholeness. This is a Connecticut case that made its way to the Supreme Court, in which a man who was never married to the mother, never adopted a child, never had any blood relationship or legal tie with the mother, with the family, but was a close family friend who had a romantic relationship off and on with the mother, decided to sue the court in order to impose his will to have visitation with the son. He also sued to have visitation with the daughter, but she was 8 years older than the son. And by the time this case made its way to the Supreme Court, she was already 18, and so she was out of the lawsuit. But basically, this man has been torturing the mother in court for years, as this decision has made its way through a full trial, a trial court, and also Supreme Court. Can you imagine the legal fees that have busted wide open this woman? The woman was never alleged to be an unfit mother. However, psychological testimony did say that she had unstable relationships. She did. She had a couple of children with a couple of different men, and she was in and out of being engaged to this one guy. So we know that that's true. But it was never said that she was not a fit mother. And essentially what happened was that the trial court found that under Connecticut statutes, as well as something called the Roth standard, R-O-T-H, which is a standard used by the court to determine this kind of case, that seeing the man was not in the best interest of the child, because the mother was so angry about it and would have imposed her energy, her negative energy, her anger on the family system, and therefore, even if he was the greatest guy that ever was, it wasn't in the interest of the son to see the father. To see this man. Well, this was appealed, and Joette Katz wrote the appellate decision, and she is now the director of DCF. And in her decision, she found that despite the fact that the trial court said that it was not in the best interest of the child, she actually imposed visitation of the man on this family. I am so shocked I cannot begin to tell you. We've invited Ms. Katz to be on the show. She is the new commissioner of DCF, and I intend to ask her about this should she decide to come on the show. But I will tell you that I'm shocked. And there was a judge who wrote a dissent, Judge Evely, who wrote a dissent in which basically he or she, and I'm not sure if it's a male or female judge, takes apart the decision. It's a very, very long dissent. But it's called the St. George case. And you could find it because all the Connecticut cases that are published are available to be found. And we're going to put the link up. I'll put it up on my Facebook page. So if you want to see it, you can friend me and I'll put it up on Facebook. But you ought to see this case. Apparently, and it gets very convoluted legally, but apparently it's the Roth case said that there is a constitutionally protected interest of parents to raise their children without interference. Okay, and that's the constitutionally protected right. However, they found an exception to that right. They said interference is justified only when it can be demonstrated that there is a compelling need to protect the child from harm. And the fact is that then the court went on to say, well, in this Roth case, that here's how we know that the impact of seeing somebody is better than not seeing anybody. Anyway, the fact is that under this case, the court held for the first time that despite the best interests of the child, a stranger could have a compelling right, could be able to be forced to visit a minor child. Do you not find that shocking?